Hearsay exceptions. List of hearsay exceptions. Declarant unavailability is required. So we got 1, former testimony exception, 2, statements against interest, 3, dying declarations, 4, statements of personal or family history, and 5, statements offered against party procuring declarants in unavailability. Declarant unavailability is immaterial if 1, there's present state of mind, 2, excited utterances, 3, present sense impression, 4, physical condition, 5, past recollection recorded, 6, business record, 7, public records or reports, 8, judgment of prior convictions, 9, ancient documents, 10, documents affecting property interests, 11, learned treaties, 12, family records, or 13, market reports. Exceptions requiring declarant unavailability. Declarant must be unavailable for these exceptions to apply. 1, former testimony, 2, statement against interest, 3, dying declarations, 4, statement of personal or family history, 5, statement offered against the parties procuring declarant's unavailability. Unavailability refers to declarant's testimony. A declarant can be in court, but her testimony is unavailable because she asserts a valid privilege. Declarant is unavailable if either A, privilege, exempt from testifying due to a privilege, B, death of physical, mental sickness, C, refusal to testify despite a court order, D, lack of memory, E, absent beyond reach of court subpoena power, and statements proponent has not been able to procure attendance or testimony. Former testimony. Testimony given by a person in an earlier proceeding or deposition may be admissible. Requirements. Former testimony is admissible if 1, declarant is currently unavailable, 2, declarant's prior testimony was given under oath, and 3, party against whom testimony is now offered was either A, a party in previous action and had an opportunity to cross-examine declarant. Motive for cross-examining declarant in former hearing must be similar to the current motive. B, a predecessor in interest of party in the previous action in which there was an opportunity to cross-examine declarant and a similar motive for doing so. So the predecessor in interest is one who has close privity type relationship with a party in an earlier proceeding. This is applicable in civil actions only. Note the MBE tests this exception. Remember that it only applies if declarant is unavailable and the prior testimony was under oath. Statements against interest. A hearsay statement is admissible if, at the time it was made, it was against the pecuniary or legal interest of the declarant. Requirements. Statements are admissible if 1, the declarant is currently unavailable, 2, statement was contrary to declarant's pecuniary, proprietary, or penal interest when made, and 3, a reasonable person would not have made the statement unless he believed it to be true. Criminal case requirement. There must also be corroborating circumstances indicating the trustworthiness of the statement. This is distinguished from party opponent's admissions. A party opponent admission is a statement by a party or a vicarious statement attributable to that party. No requirement that the statement is against the declarant's interest. A statement against interest is any statement against the declarant's interest at the time it was made. So there's no requirement that the declarant is a party in the proceeding. Dying declarations. A hearsay statement is admissible if the declarant made the statement under the belief of impending death and the statement describes the cause or circumstance of the impending death. Requirements. Statement is admissible if 1. Declarant is currently unavailable. So the unavailability is not equal to death. Death of declarant is not required. 2. The out-of-court statement was made under the belief or of impending death. Again, death is not required. Declarant must only have believed he was dying when the statement was made. And 3, statement was made regarding the cause or circumstance surrounding the belief of impending death. Only available in civil cases and homicide cases. Present sense impression and excited utterance. Present sense impression. A hearsay statement is admissible if it 1. Describes or explains an event or condition, and 2. Is made contemporaneously with the event or immediately thereafter. Timing is key. The statement must be made while or immediately after the declarant perceives the condition or event described in a statement. Excited utterance. A hearsay statement is admissible if it 1. Relates to a startling or exciting event or condition, and 2. Was made while the declarant was under the stress or excitement of the event. Declarant's emotional state is key. Declarant must be under such excitement or stress that one would not normally have an opportunity to fabricate the statement.